How does the probate process work? If you've just been named a personal representative or executor or executrix of an estate, you need to know a step-by-step description of the process. An original, signed, and executed copy of the will is delivered to the local probate court or whatever court supervises probate in your area. A notice of petition for probate is published in the local paper. This is usually a requirement prior to the normal appointment or certification of the personal representative, executor, or executrix, who is named in the will, assuming a will exists, legally referred to as testate, or a court-appointed administrator if there is no will, referred to as intestate. After the certification of or appointment of the personal representative has been made official, they then file their formal petition with the court to probate the estate. Following the steps, and generally for a legal specified period of time, 4 months is typical, from the date of public notification of petition for probate, creditors against the estate are allowed to file their claims. This includes any previously unpaid debts, other liens or judgments, debts resulting from medical care, funeral expenses, outstanding taxes, and other encumbrances. During the same period, the personal representative will be working to identify, gather, and secure the assets of the estate in such a manner as to be able to ultimately distribute them in accordance with the will or the court directives. To accomplish this, the personal representative will also need to locate and assess all bank and other types of security accounts, determine any of the remaining debts owed by the decedent that require settlement, determine any real property owned by the decedent, and secure the titles to these and other assets that will ultimately needed to be disposed of. It's also the responsibility of the personal representative to maintain these assets safely, properly, and in good condition during his period of stewardship, as well as collect any income, such as rents, residuals, interest payments, etc., that are due to the estate. To do so, the representative must be aware of and maintain proper insurance coverage, protecting the assets from theft or damage. The personal representative may also, if permitted or desired, liquidate some of the hard assets, such as cars, real estate, etc. This is often done to provide cash to pay off bills of the estate. When the formal claim period has expired and all assets have been collected, property that needed to be sold has been sold, and assuming no problems have arisen, such as any contesting of the will by any of the heirs or other contested claims against the estate, the personal representative will usually file their final petition with the probate court to allow a complete distribution of all remaining assets to the heirs and beneficiaries. This final petition includes a detailed accounting to the court, explaining all of the expenses incurred, funds and assets received and dispersed, how many assets were invested and otherwise used, and the proposed final plan for final asset distribution. Assuming the court approves this petition, the personal representative then distributes the assets as instructed in the will and detailed by the approved petition, and or as required by law or the courts that there is no will. This is Harry Copeland, aka Crazy Harry. Phone 407-603-5992. Text line 321-295-1420. HarryCopeland.com. CopelandProbateSolutions.com. HarryCopeland7@gmail.com. And Debbie's Wholesale at AOL.com for our investor friends. Until next time, thank you.